Welcome to the deep dive.
Great to be here.
Today, we're really getting into a case that, honestly, it went all the way, right up to the High Court of Australia.
Yeah, and it started with some really disturbing allegations inside this group, Kenja Communication, which, well, it had its share of controversy.
Absolutely. It's a story about, well, a charismatic leader, you could say, a young woman showing incredible courage over many years, and some really fundamental legal ideas that were, put under the microscope.
And it ended up changing how criminal trials actually run in Australia. It's huge.
So we're going to unpack all of that. The events, the people involved, how the legal fights played out court after court.
And the legal team stayed pretty much the same throughout, which is interesting in itself.
It is. Our sources, we've got the judgments, obviously, from the High Court, the NSW Court of Criminal Appeal. And we've also looked at, online press reports to get the background, the context on the people, the organization.
Crucial for understanding the whole picture.
So our mission today is to really guide you through this whole complex saga and figure out its lasting impact.
Yeah, it's where the very personal meets the very highest levels of law. You've got these abuse allegations in this unique and, for many, quite a problematic setting.
Forcing the courts to grapple with things like power, memory, delays in reporting.
And just the basics of what makes a trial fair.
Exactly. So to get this legal journey, you really have to start with the world it came from. And the man at the center, Kenneth Emmanuel Dyers.
Right. Let's talk about Dyers, the Svengali of suburbia, as some might see him.
So Kenneth Emmanuel Dyers, our sources show him as the co-founder of Kenja Communication. Started it in '82 with Jan Hamilton, his partner.
And on the surface, Kenja looked like, what, a self-help group?
Kind of, a communications group. They ran sessions, courses, all about improving your life through something called energy conversion. Dyers himself, he projected this image, wise, almost mystical, spiritual guide.
Held the keys to fixing your life, basically.
That was the image. But then you look at what ex-members said, you read the press reports, and it's a totally different story.
Yes, starkly different. While he's building this persona, he and Kenja are getting hit with serious criticism, often called a cult.
And the language used against him was strong.
Incredibly strong. We found reports quoting Stephen Much, a politician back then, using parliamentary privilege so he could speak freely. He called Dyers a seedy con man, a liar, cheat, and bully.
Wow.
And Kenja itself, he called it a sinister organization designed to fill the pockets and stroke the egos of Dyers and Hamilton. I mean, that's not just mild criticism.
No, that's a full-on public attack. Quite the contrast to spiritual guide.
Right. And Dyers wasn't young when he was doing this. Born 1922, so much older than a lot of his followers.
And his background wasn't exactly straightforward either.
No. Sources mentioned he'd been involved with Scientology earlier on, left under a cloud, apparently, declared a suppressive person, an SP, which is basically, enemy status in Scientology.
Right.
And his World War II military record, described as checkered. Court-martials involved. One journalist even suggested a Walter Mitty complex, sort of thinking it fantasy, maybe a disconnect from reality.
Interesting background for someone setting up their own group.
Well, maybe leaving Scientology like that as an SP showed him rejecting one system. But then he built another one all around himself, his charisma, plus these unique Kenja practices like energy conversion.
It allowed him to build up this status.
Yeah, almost godlike knowledge among followers. That kind of perceived power, that authority, it made it really hard to question him. And that sets the stage for potential exploitation, doesn't it?
It certainly seems like it could. And his story has a tragic end.
It does. July 2007, he was facing new sexual assault charges, a whole set of them, actually. 22 charges related to alleged assaults on 2 young girls between 2001 and 2002. The sources state he died by suicide. Gunshot.
While facing those charges. And it wasn't the first time he'd faced accusations like this, was it?
No. Back in 1993, he'd been charged over incidents involving 4 young girls. He was acquitted of most of those. But the charge related to the complainant we're calling AP. That's the one that went to trial and eventually ended up in the High Court.
So a pattern of accusations over many years.
Yes, a disturbing pattern. And his death came just as he was facing more legal action and possibly, according to reports, more police interviews about yet another allegation. It just highlights this persistent cloud that hung over him and Kenja.
Which brings us to AP, the complainant in the case we're really focusing on today. She entered the Kenja world very young.
Just 10 years old in 1986. That's incredibly young to get involved in something like this.
And crucially, when the alleged assault happened, July 1988, she was 13.
13. Her age is obviously a key factor, but her vulnerability, it was magnified, wasn't it, by her family's involvement.
Deeply involved. Her mother wasn't just a member, she was a co-director of the Melbourne branch.
So AP's whole world was Kenja. Her family, the hierarchy, the rules, the culture. She was right in the middle of it.
And the alleged incident itself happened during one of these main Kenja activities, an energy conversion session.
Yes, conducted by Dyers himself. AP testified that during this session, Dyers said she needed to clear on certain energies. Specifically mentioned sex.
Okay.
She described him telling her to take off her shirt and skirt. She did that. But she refused point blank to remove her underwear.
And what did she say happened then?
Her testimony detailed Dyers putting his hand on her stomach, touching, fondling her breasts, kissing her, pulling her towards him physically.
This is during a supposed energy conversion session.
Exactly. And when she resisted, when she wouldn't take off her underwear.
What did she say he did?
Her testimony was that he just snapped, became abusive, pushed her chair back, swore at her, called her a bitch, and stormed out.
And this session lasted how long?
She said about 3 hours, this whole encounter.
3 hours? That's
Yeah.
a long time for something like that.
It is. And her detailed account, while it paints a picture that's a million miles away from a communications group session, it sounds like alleged serious assault.
But one of the biggest hurdles in this case, legally, was the delay. She didn't report this until 1993.
That's right, 5 years after the alleged incident.
5 years. That's a long time, especially for childhood allegations.
It is. And her reason for the delay, she stated that Dyers had specifically told her not to talk about anything that happened in those sessions.
Ah, so a direct instruction for secrecy.
Exactly, which points right back to that alleged culture of secrecy and control within Kenja, where Dyers' authority was supposedly used to keep things quiet, stop people seeking outside help or scrutiny.
So it wasn't just her age, it was her family's position, the abuse happening under the spiritual guise, Dyer's authority.
And the instruction to keep silent, all creating this huge barrier to her speaking out for 5 whole years. It isolated her.
That context is so important for understanding the delay.
Absolutely. And speaking of context, let's look a bit closer at Kenja itself, beyond the PR.
Right. Publicly, they were this communications group. Energy conversion sessions, eye contact, talking personal issues, clearing negative energy.
But, like we said, surrounded by controversy, the cult label stuck.
And not just vague accusations, right? There were specific concerns.
Serious concerns. Press reports, ex-member accounts. They mentioned the tragic case of Cornelia Rao, whose severe mental health issues and wrongful detention were linked to her time in Kenja.
I remember that case.
Yeah, and numerous other ex-members reported psychological problems after leaving. Allegations of financial exploitation, intense psychological manipulation, basically designed to cut people off from the outside world and make them reliant on Kenja.
But Kenja didn't just take this criticism lying down.
No way. They fought back hard, put resources into controlling the narrative. Our sources even mentioned they produced something called guilty until proven innocent, trying to paint themselves and Dyers as victims of a witch hunt.
Okay. Now, there's another layer of complexity here. Around the specific date, July 29, 1988, the day AP says the assault happened, something else significant occurred that day.
Hugely significant. On that exact same day, AP's mother confronted Dyers about alleged financial wrongdoing in the Melbourne branch, and she was dismissed, kicked out of Kenja.
Wow. The same day.
The very same day. And that timing, well, it became a massive point in court.
I can imagine the defense must have jumped on that.
Absolutely.
Yeah.
They argued it provided a motive, that the mother's dismissal, the financial dispute, the resulting anger, could have led AP to make a false accusation against Dyers. Revenge, essentially.
So the defense narrative was this whole thing was fabricated out of spite.
That was the clear implication. But the Crown, in AP's account, offered a completely different interpretation.
Which was?
That the mother's confrontation and dismissal explained why the family left Kenja so suddenly. Not because of a false abuse claim, but because of this conflict. And that sudden departure, combined with Dyers telling AP to keep quiet.
It could have made AP feel even more isolated, afraid to speak up.
Exactly. Potentially fearing disbelief or retaliation if she disclosed what happened, especially right after her family was ousted. It could actually explain the 5-year delay, rather than undermining her claim.
So the same event, interpreted in completely opposite ways, it really shows how central Kenja's internal dynamics and Dyer's power were to the whole case.
Right. The sources suggest the very practices of Kenja, the intense energy sessions, Dyer's authority. It allegedly created an environment ripe for exploitation, and the secrecy shielded it. The alleged assault wasn't random. It was potentially enabled by the system itself.
Cloaked in this idea of a necessary clearing.
Precisely. The environment wasn't just background, it was arguably integral to the alleged crime and the delay in reporting it.
Okay. So with all that context, let's step into the courtroom. The first trial, district court.
Right. The trial started July 5, 1999. Sydney District Court. Judge Kinchington, DCJ QC, presiding.
And the charge.
Indecent assault of a minor under authority. Section 61E1A of the NSW Crimes Act. Maximum penalty back then, 6 years.
That phrase, under authority, that's key here, isn't it?
It is. It acknowledges the power imbalance. The charge wasn't just about the alleged act, but that it was done by someone in authority like a teacher, a religious leader, or, the Crown argued, someone like Dyers in Kenja.
So the charge reflected the specific context. The indictment initially covered a couple of weeks, but the Crown narrowed it down.
Yet during the trial, the prosecution focused the allegation on the morning of July 29, 1988, in that energy conversion room.
And Dyers
Pleaded not guilty, denied it all, and he made a really critical choice about how he defended himself.
He didn't testify under oath.
Correct. He chose not to give sworn evidence, which meant he couldn't be cross-examined by the prosecutor. Instead, he made an unsworn statement from the dock.
Which was allowed back then in NSW.
It was a way for the accused to give their version without facing cross-examination, though generally it's seen as carrying less weight than sworn testimony. It's been abolished since then.
So what did he say in this unsworn statement?
He flatly denied AP's account, said he had no contact with her alone that morning, only saw her briefly when she was with her mother during other meetings he had scheduled.
He specifically denied the energy conversion session.
Categorically. Denied doing one with her that day, or ever, in Sydney or anywhere else.
So he offered a different timeline for that morning, an alibi.
Exactly. He claimed that during the time AP said the assault happened roughly 9:30 to 11:30 a.m. his picks. He was busy with other appointments. Specifically, he claimed he was in a processing session, another Kenja term it seems, with a Mrs. Wendy Tinkler.
Right, the Wendy Tinkler alibi. Did they have evidence for that?
Yes. His appointment diary was key for the defense. They tendered it. It showed meetings for that day, including one with AP's mother from 1 to 3 p.m.
And did it show the Tinkler meeting?
It showed an entry for WT, presumably Wendy Tinkler covering that 9:30 to 11:30 slot. But crucially, no entry for AP at all.
And the defense called witnesses?
We did. Michelle Ring, Diana Moore, Michael Strang, and significantly, Amanda Hamilton. She was Dyer's personal assistant and his sister-in-law. She testified about the diary, backing up the claim Dyers was scheduled to be with Tinkler.
And they also brought up the mother's financial issues again.
Yes, that was another line of attack. Trying to bring in evidence about the mother's alleged financial problems at Kenja and her dismissal, suggesting that was the real reason for the accusation. A motive.
Okay, so we have the Crown's case with AP's testimony and the Kenja context, and the defense with Dyer's denial, the alibi, the diary witnesses, and this alternative motive theory. Who were the lawyers fighting this out?
For Dyers, the appellant, counsel was Mr. M.C. Ramage, QC, instructed by solicitors Henry Davis York.
And for the Crown?
Mr. P.G. Berman of counsel, instructed by Mr. S.E. O'Connor from the Solicitor for Public Prosecutions, acting for the DPP. And importantly, these are the same lawyers who stuck with the case right through the appeals.
That is unusual. The sources mentioned the trial itself was quite tense.
It sounds like it. The defense was clearly worried the trial was becoming a trial of Kenja itself, not just Dyers. They objected to what they saw as prejudicial smears, like linking Kenja to Scientology.
And the judge.
Judge Kinchington tried to keep the focus, explicitly told the jury Kenja wasn't on trial. Their job was just to decide if the Crown proved the charge against Dyers beyond reasonable doubt.
But despite the defense arguments, the alibi, the complexities, what did the jury decide?
The jury found Kenneth Dyers guilty.
Guilty, so conviction at the first stage. But that wasn't the end of it. He appealed.
Straight away. Appealed both the conviction and the sentence he received to the NSW Court of Criminal Appeal, the NSWCCA. The judges hearing that were Stein J.A., Smart A.J., and Ireland A.J.
And the legal team still Ramage QC for Dyers and Berman for the Crown.
Yes, exactly the same counsel and solicitors. Consistency right through.
So what were Dyers' main arguments to the Court of Appeal? Why should the conviction be overturned?
They raised quite a few grounds. Firstly, that argument again. The trial miscarried because it focused too much on Kenja and the Scientology stuff, prejudicing the jury.
And the Court of Appeals response.
Rejected. They agreed with the trial judge. He told the jury Kenja wasn't on trial. They didn't think the Scientology references were enough to cause a miscarriage.
Oh, wait, what else? The verdict itself? Unreasonable.
Yes, that was a big one. The defense pointed to the 5-year delay, alleged inconsistencies in AP's evidence, arguing no reasonable jury could have convicted.
How did the NSWCCA handle that?
They rejected that too. They really hammered the point that assessing witness credibility is the jury's job. They see the witnesses, hear them. An appeal court shouldn't just second-guess that unless the verdict is truly perverse, basically something no reasonable jury could possibly reach. They cited MV the Queen on that.
And didn't they make a specific point about Dyers not testifying under oath?
They did. And this became really controversial later. The NSWCCA said his decision to make an unsworn statement, avoiding cross-examination, was a substantial impediment to arguing the verdict was unreasonable, citing R.V. Gordon and Gordon, essentially saying by not putting his sworn evidence up to be tested, he made it harder to argue the jury was wrong to believe the complainant.
Right. That feels like a potential catch-22 for an accused person.
It does, and it was heavily criticized later. Other grounds. Issues with directions on inconsistent evidence leave refused. Complaint about the Crown's opening statement not matching evidence rejected, noting the defense hadn't asked for a discharge at the time.
And the Jones v. Dunkel direction, that came up again.
Yes. The defense argued the trial judge was wrong to give that direction, allowing the jury to draw an adverse inference because Dyers didn't call certain witnesses, especially Wendy Tinkler, his alibi witness.
What did the Court of Appeals say about that?
They rejected it. They saw the judge's direction as potentially applying to both sides, a bipartisan direction, and they said it wasn't unfair here. Crucially, they said the High Court case, RPS v. the Queen, which limited comment on the accused not testifying, didn't stop a Jones v. Dunkel direction about failing to call other witnesses. So they found no error there.
Okay, so the Court of Appeal upheld the Jones v. Dunkel direction in this context. Any other points?
Yep. They argued the judge shouldn't have stopped the defense using visual aids, like placards, in closing. Rejected judge's discretion, no miscarriage. Then the delay issue, again arguing the judge's Longman direction wasn't strong enough.
Longman, the big case on warnings about delayed sexual assault complaints.
Exactly. Longman says judges must warn juries about the dangers of convicting on delayed evidence because delay harms the defense's ability to test claims. The defense argued the judge needed to give an explicit, dangerous to convict warning here.
And the Court of Appeal
Rejected. They found the judge's directions were adequate overall. He told the jury to carefully scrutinize AP's evidence because of the delay. They said a specific dangerous warning isn't always mandatory. It depends on the circumstances and other warnings given.
And a final argument about the judge's summing up being unbalanced.
Also rejected.
So basically, the NSW Court of Criminal Appeal shot down every single argument against the conviction.
That's right. Appeal against conviction. Dismissed. The guilty verdict stood firm at that stage.
But he had also appealed the sentence. What happened with that?
He'd received 12 months in custody from the district court. He argued it was too harsh. The judge considered irrelevant facts, didn't give enough weight to the delay. His age, he was 78 by then, nearly 80 at the appeal. His poor health, prior good character.
Was he successful there?
Yes, he was. The Court of Appeal didn't actually find fault with the original judge's sentencing reasoning. But, and this was critical, new medical evidence came out during the appeal.
Showing his health had gotten worse?
Significantly worse since the trial. And the court gave this new evidence a lot of weight. They decided, based on his current health, it wouldn't be right for him to go back to prison.
So they changed the sentence.
They did. Granted leave to appeal the sentence, upheld the appeal, scrapped the original custodial sentence. They imposed a new 12-month sentence, but it was wholly suspended, conditional on a good behavior bond.
Ah, so the conviction remained, but he avoided more jail time because of his health.
Exactly. Conviction stood, sentence suspended.
But Dyers still wasn't finished. He wasn't accepting that conviction. He took it higher still.
All the way to the High Court of Australia. He had special leave to appeal the NSWCCA's dismissal of his conviction appeal. The case became Dyers v. the Queen, heard by 6 High Court justices: Gaudron, McHugh, Gameau, Kirby, Hain, and Callanan.
Incredibly, the same legal teams again. Ramage QC versus Berman.
Still the same. Mr. M.C. Ramage QC for Dyers, instructed by Henry Davis York. Mr. P.G. Berman for the Crown, instructed by the Solicitor for Public Prosecutions. 3 courts, same counsel facing off.
Remarkable. So, after the Court of Appeal rejected everything, what was the key issue that the High Court focused on? What turned the tide?
It really came down to that Jones v. Dunkel direction. While other grounds were argued, the majority of the High Court zeroed in on whether the trial judge was wrong to tell the jury they could draw that negative inference against Dyers for not calling witnesses, especially Wendy Tinkler.
So, the very point the Court of Appeal said was okay, the High Court saw it differently.
Fundamentally differently. The majority justices Gowdron and Hayne, with Kirby and Callanan agreeing on this point, found that giving that Jones v. Dunkel direction against Dyers was a material error, a mistake serious enough to mean the conviction had to be quashed.
Why? What was the High Court's reasoning? Why was it an error here?
They laid out several core reasons, going right to the heart of how criminal trials work in Australia. First, the big one. Our system is accusatorial. The prosecution has to prove guilt beyond reasonable doubt. The accused has the right to silence, doesn't have to prove anything. So the majority said it will seldom, if ever, be reasonable to conclude that an accused in a criminal trial would be expected to call evidence or witnesses, because the burden is entirely on the Crown.
So giving a Jones v. Dunkel direction against the defense, it undermines that whole principle. It shifts the burden.
Exactly. It suggests the defense has some explaining to do if they don't call someone, potentially pressuring them to call witnesses and implying they have a burden to disprove the Crown's case. That fundamentally contradicts the presumption of innocence and the Crown's burden.
What else did the majority say?
Second, they criticized the trial judge for not giving the jury clear guidance. When would you expect a witness to be called? What's a satisfactory explanation for not calling them? It was vague, and the prosecution hadn't really laid any groundwork to show Tinkler was definitely in the defense camp or only available to them.
So a confusing instruction without a proper foundation.
Yes. Third, they pointed to the prosecution's duty under cases like apostolides to call all material witnesses relevant to the case, even if they don't perfectly fit the Crown narrative. If Tinkler's evidence about the alibi was truly important, the argument goes, maybe the Crown should have called her to present the whole truth, rather than the defense being penalized for her absence.
That's a really important distinction about who carries the responsibility.
It is. Fourth, the contradiction. The judge told the jury not to speculate about uncalled witnesses, then immediately invited them to infer something negative about why they weren't called. Logically, those clash. The High Court said the right instruction is just. Don't speculate. Decide on the evidence you did hear.
That seems like a clear flaw in the summing up.
The majority thought so. Fifth, they said the fact Dyers raised an alibi didn't change things. An alibi is just an alternative explanation. The accused doesn't have to prove it. The jury's job is still just to see if the Crown disproved the alibi beyond reasonable doubt with its evidence. You don't penalize the defense for not bolstering the alibi.
And did it matter that Dyers had used an unsworn statement? Did that affect the Jones v. Dunkel error?
No, the majority made it clear. The error wasn't dependent on the unsworn statement. The direction would have been wrong, even if Dyers had given sworn evidence, but still chosen not to call Tinkler. The error was applying that adverse inference principle against the defense in a criminal trial, period.
And the Court of Appeal's idea that it was okay because it was bipartisan applied to both sides.
The High Court majority rejected that, too. They said you can't just treat the Crown and the accused symmetrically like that. Their obligations, resources, and roles are totally different. The witnesses in question here were mainly relevant because of the defense alibi, not necessarily material witnesses. The Crown had a duty to call for its own case. So a symmetrical failure to call inference just doesn't work.
So the High Court majority was crystal clear. Giving that Jones v. Dunkel direction against Dyers was a fundamental error.
Unequivocal. A material misdirection. And they decided the proviso, the rule that lets an appeal court uphold a conviction despite an error if no substantial miscarriage of justice occurred, couldn't save it here. The error was too significant, too fundamental to trial fairness.
Did the High Court look at the other appeal grounds too, like the unreasonable verdict argument or the longman delay issue?
They did discuss them. On the unreasonable verdict point, Justices Kirby and Callanan strongly criticized the NSWCCA's reasoning about the unsworn statement being an impediment. They agreed that was wrong. Penalizing Dyers for using a lawful option undermined his rights. Justice Callanan did review the evidence himself, though, and felt that while the NSWCCA's reasoning on the unsworn statement was flawed, The evidence alone didn't demand an acquittal.
So they corrected the Court of Appeal on that specific point about the unsworn statement. What about the Longman delay direction?
Justices Gowdron and Hayne didn't need to rule definitively on Longman because the Jones v. Dunkel error was enough to quash the conviction. But Justice Kirby said he wouldn't have overturned it just on the Longman ground here, though he stressed how important Longman warnings are. Justice Callan actually found the trial judge's specific directions on delay in this case were sufficient, pointing out the judge had covered the delay, the reason given, AP's age, the context, and the disadvantage to the defense.
So Jones v. Dunkel was the killer blow for the conviction, but the case also involved important discussions about these other areas.
Absolutely. It reinforced principles around unsworn statements and delayed complaints, even if they weren't the deciding factors for the majority verdict.
Now, we know the majority quashed the conviction, but there was a dissenting voice, wasn't there?
Yes, Justice McHugh disagrees strongly. He wrote a detailed dissent. His fundamental point was that he believed a judge can comment and let the jury draw adverse inferences when an accused fails to call witnesses if the accused puts forward an affirmative defense case.
So, because Dyers didn't just deny it, but put up an alibi saying he was with Tinkler, Justice McHugh thought that changed the game.
That was his core argument. He looked back at old cases like R.V. Burdett from 1820 and drew parallels with how Jones v. Dunkel works in civil cases. He argued that the high court cases like RPS and As a Party, which stopped judges commenting on the accused themselves not testifying, didn't necessarily stop comment on failing to call other witnesses when an affirmative defense like an alibi is raised.
How did he view the Wendy Tinkler situation specifically?
He argued her relevance really ramped up because Dyers claimed she was his alibi. So in McHugh J's view, if you claim someone can back up your story and you don't call them, that is something the judge can comment on. He felt it shifted the practical expectation, less expectation on the Crown to call her, more potential significance if the defense didn't. He even pointed to a specific section of the NSW Crimes Act at the time that allowed comment if an accused didn't call their spouse or child, suggesting the law already accepted comment on absent witnesses sometimes.
So a fundamental disagreement about where the line is drawn when an accused offers an alibi.
Exactly. McHugh J. thought the alibi defense opened the door to the Jones v. Dunkel comment. The majority thought the fundamental principles of the accusatorial trial meant that doors should remain firmly shut against the defense. McHugh also noted the defense hadn't objected at trial, but the majority didn't see that as a barrier to the appeal succeeding.
Okay, so despite that strong dissent, the final order from the High Court was?
By majority, appeal allowed. The NSWCCA order dismissing the conviction appeal was set aside, which meant Kenneth Dyers' conviction for indecently assaulting AP was quashed. Gone.
And unusually, the High Court decided not to order a new trial on this charge.
Correct. That's a discretionary call. Several factors played into that decision not to retry AP's case. The huge delay, 14 years since the alleged offense by then, Dyers' age and poor health, which the NSWCCA had already acted on, the fact he'd served the custodial part of the original sentence, even if it was later suspended, plus just the sheer length of the legal battle, the arguments about evidence problems due to delay, and the feeling that putting him through a third trial on this specific charge after all that time might itself be an injustice.
So time, health, the history of the case, all led them to say enough is enough on this particular charge.
Essentially, yes. While the decision turned on a legal error in the judge's directions, the practical result for the charge involving AP was effectively an acquittal. Conviction wiped, no retrial.
So this case, Dyers v. the Queen, it wasn't just about one conviction. It had major ripple effects on how criminal law is practiced in Australia, didn't it?
Oh, absolutely. It really drew a line in the sand, especially regarding Jones v. Dunkel. You could say the High Court delivered the death knell for using that principle to draw adverse inferences against the accused in criminal trials, at least in the way it had been attempted here.
So judges just can't tell juries anymore, well, the defense didn't call witness X. Maybe you can assume their evidence wouldn't have helped.
Pretty much. Dyers shut that down for the defense case. It was a massive reinforcement of those core principles. Right to silence, presumption of innocence, burden of proof is always on the prosecution. The court made it clear you can't use directions about absent witnesses to subtly undermine those rights or pressure the accused. Legal experts agree. Dyers confined the main force of Jones v. Dunkel adverse inferences largely to civil cases when it comes to a party not calling witnesses.
How does that change things tactically for lawyers now?
Well, prosecutors know they can't ask for that direction against the defense if a witness isn't called, even an alibi witness. Defense lawyers know their decision not to call someone, maybe for strategic reasons, cost, availability, maybe the witness is unreliable for other reasons, won't result in the judge inviting the jury to hold it against them. It forces the prosecution to win on the strength of their own evidence, not by pointing to gaps in the defense presentation caused by absent witnesses. And although it wasn't the deciding point, Dyers also really underlined the importance of the longman warnings about delayed complaints.
Solidified the need for those strong directions from judges.
Exactly. Even though some justices thought the direction here was okay, the whole discussion reinforced how vital it is for judges to give clear, strong warnings when there's been a significant delay in reporting sexual assault, because delay does disadvantage the defense. The debate in Dyers reminds judges just how carefully they need to apply longmen.
And that point about the unsworn statement being an impediment on appeal.
The High Court basically slapped that down. Justices Kirby and Callanan were clear. You can't penalize an accused on appeal for using legal option they had at trial, like making an unsworn statement back when it was allowed. The broader principle holds even though unsworn statements are gone now. Exercising a lawful right during trial shouldn't count against you later.
And by restricting Jones v. Dunkel against the defense, did Dyers indirectly put more focus back onto the prosecution's duties?
You could definitely argue that. By removing that tool against the defense, it implicitly highlights the prosecution's duty under hostilities to call all material witnesses. If a witness is genuinely important for the whole story, the pressure is more on the Crown to call them, rather than the defense getting negatively judged if they don't. The High Court rejected the bipartisan idea because the Crown and defense aren't equal players. The Crown has the duty to present the full picture. Dyers makes it harder for the Crown to pick and choose witnesses and then benefit if the defense doesn't fill the gaps.
So bottom line, Dyers v. the Queen was a huge case. Clarified and strengthened core ideas of Australian criminal justice, presumption of innocence, right to silence, burden of proof, especially around how judges talk about absent witnesses.
Absolutely. The really unique, difficult circumstances of the allegations inside this controversial group, the long delay it forced the system to really examine its own rules to ensure fairness, even in tough cases. It showed how a deeply personal story within a closed world could reach the very top and lead to fundamental legal clarification.
Now, as we finish up, it's worth remembering that even though the High Court quashed the conviction involving AP, Kenneth Dyers' legal issues and the cloud over Kenja didn't just disappear.
No, not at all. As we mentioned, new serious sexual assault charges were laid against him in 2005, relating to alleged incidents in 2001, 2002.
And it was while those charges were hanging over him and apparently police were looking into yet another allegation that he took his own life in July 2007.
Yeah, a tragic end. And Kenja itself remained controversial. Still linked to the Cornelia Rao case, still facing criticism from ex-members about manipulation and mental health impacts. And very notably, they refused to join the National Redress Scheme for survivors of institutional child sexual abuse. That drew a lot of criticism.
So the Dyers High Court case, while focused on procedural fairness and resulting in the quashing of that specific conviction, was really just one part of a much longer, darker public story involving Dyers and Kenja. It certainly brought the group's dynamics into the spotlight.
Definitely. A real intersection of personal tragedy, organizational controversy, and a landmark legal case that reshaped Australian criminal law.
So, we've taken a deep dive into the Dyers case, a legal and human drama stretching over years and across courts. From the confines of a controversial organization to the highest judicial bench in Australia, this case clarified crucial principles about the rights of the accused, the burden of proof, and how courts should handle issues like delayed complaints and absent witnesses. It reminds us that the legal framework constantly evolves to balance protecting individuals, ensuring fair trials, and seeking justice.
It really does. And it highlights that tension, doesn't it? Especially in these cases within closed groups, power imbalances, long delays, evidence is hard to come by, memories fade, people might have been silenced. Dyer strongly upheld the accused's rights, but the underlying challenge for the system how to handle these incredibly difficult factual situations fairly, that remains.
So here's something to think about. The Dyers case powerfully reaffirmed the foundational rights of an accused person, scrutinizing things like judicial directions very closely. But in those really complex cases, allegations within closed groups, significant delays making evidence scarce. How does the justice system find that balance? How does it ensure fairness to the accused while still providing a pathway to accountability for alleged wrongdoing, especially when the very environment where the acts allegedly happened made it so hard to gather evidence or complain at the time?
A tough question with no easy answers.
Join us next time on The Deep Dive.